Hey, I'm Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama. In this video, I want to take a few minutes and talk about the HITECH Act that deals with the request of medical records. Over the last several years, the cost and expenses associated with patients and individuals who need their medical records for legal reasons, for Social Security reasons, and otherwise, it's become increasingly more and more expensive. Well, the HITECH Act was passed several years ago, and it's supposed to help alleviate some of those costs. It gives some ground rules and some just different dynamics the way that it's supposed to help people who are in need of those records. This is when a person makes an application to their healthcare provider for records, and it comes from the patient themselves, not from a lawyer or representative, but the healthcare provider. When they get the proper request from the patient, they're supposed to comply. And we've compiled a list of questions and answers that I'm hoping will also help address some of these concerns. Question: I have a request made by a patient asking for a copy of their records in electronic format. Can a patient be charged for this fee and per page copy fee? And the answer is no, because the HITECH Act is a federal law, and federal law preempts state law. The HITECH Act states that you can charge or be charged $6.50. Alternatively, the provider who is copying these records can charge a reasonable cost-based fee for producing electronic records when it's requested directly from the patient. This means the labor cost of producing the records, which could be that labor cost to put in the records onto a CD plus postage. Next, can a scan of paper records and be put on, if you don't have electronic version, can they be scanned and put on a CD? The answer to that is yes, but you can't overcharge. There are guidelines. You can't be overcharged for this process. There can be a flat fee, and you need to talk about the fees associated with the healthcare providers themselves before you get a big bill or are surprised about those things. If your doctor, if the healthcare provider does not keep records in electronic form, can they be charged? Can you, as the patient requesting, be charged the state old regulation fees for postage and handling and the like? Again, the answer is no. The HITECH Act limits it to $6.50 plus postage and handling and maybe a few other associated costs, but not the old state regulations basing on costs. Let's see. We've got paper that is of records for your healthcare provider. Let's say you have not seen them in many, many years, and they keep them in a storage unit in physical form. Can you be charged for the labor going to retrieve all of those? Again, under the HITECH Act, the patient has the broad right to all of their records regardless of how they're maintained. But they should be put into a CD. You cannot be charged per page fee to have those records scanned and so forth. What about x-rays? What about those films that can't be scanned? You can be charged if you need those actual films themselves. They need to be put in a readily producible format in the manner that's been requested, and that probably could be on a CD, but the best practices is to get a quote for the cost from the provider to figure out if that's something that you want to spend. Sometimes the provider may have to send it out to a third-party vendor to have that put in a format where you can use it. Just a couple more questions here. What if the patient's attorney sends a letter? What happens in that regard dealing with the HITECH Act? Again, the request has to come in writing from the patient, not from the patient's representative or lawyer. However, if they request that the records be sent directly to the lawyer or representative, yes, that can be, as long as it's in writing from the patient, that is a proper request. What if you want what if you're concerned from the healthcare provider says we can't do that because we're afraid of a data breach, meaning that they don't want to email the records to your lawyer or your representative? Well, have them mail it in a CD. On the other hand, they're not responsible, once they send out the records, they're not responsible for those data breaches when it's transferred from email to email. And the deadline is 30 days. So once you make a request and it's received, they have 30 days to respond to your HITECH written request from a patient. I know this is kind of confusing set of criteria under this federal law, but if you have questions or concerns, just give us a call because we want to make this as easy as possible. 205-930-6900, that's our office. Nomberglaw.com is our website. You can also, if you subscribe to this channel, and you'll receive the videos as they come out each week.